Good morning. Welcome to another edition of Questions for Lawyers. I'm personal injury attorney Jeff Adelman, and I'm privileged to have with me today an attorney who handles a very interesting area of the law that I get a lot of questions about, labor and employment law. I'd like to introduce everybody to Richard Tuschman.
Good morning, Jeff.
Can you tell everybody a little bit about your practice, Richard?
Sure. So I have a solo firm here in Plantation, and I represent both employers and employees, obviously in different cases. And I've been practicing employment law for 27 years. About 3.5 years ago, I started my own firm, and it's going strong. I have a lot of work, and I do primarily, I would say, defense work these days. I do have some plaintiffs' cases. I also represent a lot of executives concerning their separation agreements and their employment agreements. I also do a lot of counseling for corporate clients.
Richard, if you could you tell the audience your telephone number and your email address?
Sure. The main line for my office is 954-369-1050. And my email address is rtuschman, it's RTUSCHMAN, at gtemploymentlawyers.com. GT is a reference to, I had a partner when I started, and he left the firm about 1.5 years after we started. He actually took a job with a friend of mine. So it was a very amicable parting of ways, but I kept the email domain because it was just convenient to do that.
And that's how you and I know each other, through that partner, Jeff Goods.
That's right, yeah.
So, good wrestling fan, and, I'm only friends with Jeffs, so, figure it. Because you're friends with them, I'm friends with you too.
Right.
But in any event, can you explain how you got involved in this field? Because I really don't know that many people that do what you do, Richard.
Well, I really started in law school. I was kind of nervous about getting a job when I was in law school. The job market was not that good, and I decided around my second year that I should specialize in something. So I decided that labor and employment law seemed like a good area to specialize in. Mm-hmm. And I started taking courses as much as I could in law school on Fair Labor Standards Act, which is the law that governs overtime, on equal employment opportunity law, on labor law, traditional labor law, which really refers to the law governing employers and labor unions and how they interact. And I just continued that through the end of law school. And then when I came down to South Florida, I was able to sort of say, legitimately, I am interested in employment law. And I got a job with a boutique labor and employment firm called Muller Mintz. That was in 1991. And I've been doing labor and employment law in South Florida since then.
And in fact, you're board certified in labor law, isn't that correct?
Correct. That's right.
What do you have to do to get board certified, Richard?
So you have to meet certain experiential requirements. You have to be in practice. I don't know the exact requirements. I think it's at least 10 years of practice. You have to demonstrate that you've had certain experiences in the courtroom and with depositions and mediation. And then you have to take an exam. And it's a pretty rigorous exam, and it requires a lot of study. And if you meet all those requirements and you get recommendations from your peers, you can become board certified.
Understood. And that's a certification through the Florida Bar.
Correct. That's right.
Now, in my practice, when I get calls concerning labor and employment, it's usually in the realm of a wrongful termination type of matter. Do you handle those type of cases?
I do. So again,
tell us what that is. What is wrongful termination?
So to be clear, I represent both employees in some cases, those would be the plaintiff side cases, and employers in many other cases. I have many corporate law clients, and I represent them in wrongful termination cases. So wrongful termination is just sort of a generic description for what we might call an unlawful termination, a termination that violates some statute, typically, or possibly a contract, an employment contract. Not many employees in Florida have employment contracts. The vast majority of employees are what we call at-will employees, meaning they can be terminated for any reason so long as it's not an illegal reason prohibited by statute. So I would say the vast majority of cases when we're talking about wrongful termination, we're looking at whether the termination violated a particular statute, such as Title VII of the Civil Rights Act, which prohibits discrimination based on race, color, religion, sex, national origin, or age discrimination, which is prohibited by the Age Discrimination and Employment Act, or the Americans with Disabilities Act, or the Family Medical Leave Act, or the Florida Whistleblowers Act. These are the main laws that govern wrongful termination. When you get calls, Jeff, I suspect that a lot of times employees are calling feeling that they have been wrongfully treated, but they may not really be describing a wrongful termination in the sense of an unlawful termination. So I would say the vast majority of cases or potential cases that I get calls on involve situations where an employee feels that they've been just unfairly treated. And while that, I don't condone unfair treatment of anyone in the workplace, in many cases that's not unlawful. We employment lawyers kind of have to find a box, if you will, that the wrongful termination fits into. And if it doesn't fit into one of those boxes, then we default to the at-will employment rule, which says that an employer can terminate an employee for any reason, so long as it's not prohibited by law.
And you had mentioned before that Florida is an at-will employment state. What makes Florida an at-will employment state?
Well, it's really just a matter of common law being incorporated in Florida judicial decisions that go back probably 150 years or so.
Well, Florida Constitution crystallized it too, right?
I'm not aware that there's a provision in the Constitution. You may have me on that one. I apologize, but there, at least under judicial decisions, the long-standing rule is that unless prohibited by law or by contract, an employer can terminate an employee for any reason it wishes. Now, there is there's a provision in the Constitution that says that Florida is a right-to-work state.
That's what I'm referring to.
Right. Okay. Well, it's a good question. It's actually sort of a misnomer in the sense that right to work doesn't refer to at-will employment. Those are two separate concepts. The right to work concept means that an employee cannot be required to join a union in order to gain employment in Florida. That would be prohibited by the Constitution.
I think I crossed those two things up, but I appreciate it. And
it's fine. And it's a very common misconception. So I often hear employees say it's a right to work state. They can fire me for any reason. And those are really two different concepts. So, but the right to work concept is important in the following sense. Because Florida is a right to work state, the vast majority of workers in the private sector are not in unions because they don't have to be members of unions to get a job, and for other reasons probably that go beyond our conversation. Unions have really not taken a strong foothold in Florida, at least in the private sector. Public sector is a different situation. So most employees in Florida, again, in the private sector, are non-unionized employees, which means they're not protected by a collective bargaining agreement. They're not protected by a contract. And that means that they are at-will employees. So there is a relation between the concepts, but they are distinct concepts. Understood.
And again, this is Florida law. It's different depending on what state you are employed in, correct?
That's right. And I practice, exclusively in Florida. I sometimes, will counsel employers on employment issues in other states, but you have to be careful as an employment lawyer that you have an understanding of what those other states' laws are. And if you're not sure, you often have to refer the matter out to an out-of-state attorney.
Now, with regards to a wrongful termination, whether it be for racial discrimination, gender discrimination, anything like that, does it matter how large the corporation is?
It does. That's a big factor. So that's the first.
Tell us a little bit about that.
Sure. So the first question, if a potential plaintiff comes to me, an employee who claims that she's been wrongfully terminated, for example, the first question I ask is, well, who is your employer? I want to make sure that I don't have a conflict of interest. But second question is, how many employees does that employer have? Because if they have fewer than 15 employees, then they're not covered by the federal laws governing discrimination, and they're not covered by the state law governing discrimination, which is the Florida Civil Rights Act. Now, there may be local ordinances depending on the county that the employee works in. So for example, there's a Broward County Human Rights Ordinance. There's a Miami-Dade County Human Rights Ordinance as well. And those laws apply to employers with 5 or more employees, but they don't allow you to go to court. So it's sort of a different procedure.
So hypothetically, let's just say somebody in an office setting, a small office, even a law firm, an accounting firm, anything like that, if they chose to let somebody go based on their age, could they do that if they were, say, a 4-person business?
Yes. Yeah.
A lot of people don't know that.
Yeah, it's true. And you know, it comes as a surprise to many people that in essence, that those mom and pop shops, if you will, get a free pass on discrimination. And that is the law. I mean, and there's really not much a person could do about it. You could, unless there was some other employment related claim, for example, some kind of tort, but that would be very unusual. So I would say yes. The answer is a 4-person firm could get away with age discrimination, for example.
Now, what is the EEOC?
So the EEOC is the Equal Employment Opportunity Commission. It's the federal agency that enforces several employment discrimination laws on the federal level. Mm-hmm. Title VII, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. And those laws require that in order for an employee to go to court alleging discrimination, the employee must first file a charge with the EEOC. Mm-hmm. Then the EEOC investigates the charge, typically asks the employer for its position, what we call a position statement. Right. And then at some point, it often takes quite a long time, the EEOC issues a determination as to whether they believe there was a violation of the statute or whether they're unable to conclude there was a violation.
So that would be
basically, go ahead.
That would be a prerequisite before filing that.
Correct. It's a prerequisite. And in fact, under federal law, and we can get into the weeds and the procedures here, but under federal law, the employee under most of the statutes has to get what we call a right to sue notice before filing suit under federal law.
Interesting. It's sort of like with when I have a personal injury case involving the government, I have to give them notice for 6 months before I can do anything as a prerequisite. Now, they don't have to agree with it, but in the EEOC, would they have to agree that there is something potentially actionable before you could proceed?
No. And that's that's an interesting question, and it really sort of highlights the what many employment lawyers kind of perceive as the lack of utility at the EEOC level. So the charge has to be filed. The EEOC investigates. In the vast majority of cases, the EEOC does not find cause to believe there was discrimination, but it doesn't really matter in terms of the employee's ability to file suit. Once the EEOC issues that determination, whatever it is, the employee gets a right to sue notice and the employee can proceed to court.
Understood. So, and actually, it is somewhat similar in that way.
Yeah, it's
to sovereign immunity.
Yeah, I mean, I kind of think of it, I describe it sometimes like a toll booth that the employee must go through. It's not going to stop. It's not a stop sign or a red light. The employee has to go through this EEOC toll booth. But at the end of the day, the employee will be able to file suit, whatever the EEOC's determination is.
I want to talk to you a little bit about protected classes in terms of who is protected from discrimination. And in particular, I want to talk about Florida because I believe it's different depending on what state you go to, correct?
There are some differences in the laws, that's right. And frankly, not only among states, but among localities, like different. For example, in some municipalities, sexual orientation discrimination is prohibited, but it's not prohibited by state law, nor is it prohibited by federal law, which surprises many people, but that is the case.
So, for example, in Broward County, would that be protected?
Yes. So under the Broward County local ordinance, sexual orientation discrimination is prohibited in the workplace. And so if that's all that the employee were alleging, the employee would have to file his case with the Broward County Human Rights Division because there is, well, I'm pausing on sexual orientation because the law is kind of in a state of flux right now. And some courts are recognizing that at the federal level, sexual orientation discrimination is a form of sex discrimination protected by Title VII. But the weight of authority, most courts say that sexual orientation discrimination per se is not prohibited by Title VII. So yes, the employee would then have to go to the local agency to vindicate his rights.
Understood. So it could be different in different parts of Florida, let alone the
exactly.
United States.
That's right. That's right.
What's a hostile work environment claim?
Yeah, so that's a really good question, and probably one of the most common issues, and it kind of relates to the wrongful discharge theme we were talking about earlier. So a lot of employees complain that they're being subjected to a hostile work environment. They've heard that term. It's kind of a buzz phrase that's used.
Yep,
and
I'm using
it has kind of, yeah, exactly. And it has kind of two meanings. It has kind of what I'd call a generic meaning, where an employee is being mistreated at work, being verbally abused, being criticized, incessantly, maybe being bullied by the boss or by coworkers. All of that might generically be called a hostile work environment. But the important point from a legal perspective is that a hostile work environment is not illegal unless it's hostile because the employee can show that the employer is taking this action because of the employee's protected status, meaning because of the employee's sex, race, color, religion, national origin, etc. So if you have an employee who, let's say, for example, let's say it's a Cuban American and she's complaining that she's subjected to a hostile work environment, and I ask her, well, who's subjecting you to this hostile work environment? And she names her boss, and his name is Diego, and he's also Cuban American. And the hostile work environment has nothing to do with their national origin. He's Cuban American, she's Cuban American. She's just feeling, unfairly treated by Diego. Right. That would not state a legal claim for a hostile work environment. The classic case of a legal claim of hostile work environment is where an employee is being sexually harassed at work by her boss, for example, and he's creating this hostile work environment. He may not have taken any adverse employment action against her. He may not have, for example, demoted her, lowered her pay, or taken any other action against her, but perhaps he's subjecting her to unwanted sexual advances on a regular basis. That would be a legal claim for a hostile work environment under Title VII, the law that prohibits sexual discrimination.
Going back to something you said before and I had asked you about, a claim like that, is that determined at all by the size of the company, or can anybody bring that type of a claim?
Right. So those claims are governed by the same laws that govern employment discrimination. In fact, a hostile work environment, if it's actionable at all, is actionable because it's prohibited by one of those laws.
Right.
So it falls under the same standard.
So again, if going back to my scenario, somebody runs a small mom and pop business, 4 people. If somebody's making inappropriate sexual advances or anything like that, or sexual comments, the solution is to leave. You can't really bring a claim. Is that right?
That's right. And that may surprise some of your listeners or viewers, because you think, wow, and a company with 4 employees can get away with sexual harassment. And if that's all that there is, meaning sexual comments, sexually charged behavior in the workplace, but nothing that crosses the line into a tort.
No touching or anything like that.
Right, no touching, so no battery, then in a very real sense, the employer, that small employer can get away with sexual harassment. It's just not prohibited by law.
Can you talk a little bit about the Family Medical Leave Act? And
sure.
Handle those. Do you have cases involving FMLA?
I do. I have quite a few, actually. One of my employers is a very large employer, about 16. One of my clients is a very large employer with 1,600 or so employees. And so they get quite a number of claims under the Family Medical Leave Act. The Family Medical Leave Act is, first of all, it applies to larger employers with 50 employees or more.
Wow.
And furthermore, to be eligible, an employee must work in a location where the 50 employees work within 75 miles. So, for example, if you had an employer with 60 employees, but 20 were in Miami and 20 were in Orlando and 20 were up in Jacksonville, none of those employees would be eligible under the FMLA. But let's assume that an employee is eligible for FMLA leave. What does that law do? Well, it protects the employee. It protects the employee's job if the employee needs to take leave because of the employee's serious health condition or the serious health condition of an immediate family member. So it basically allows the employee to take some time off from work. It's unpaid leave.
Right.
Or at least the law doesn't require that it be paid. And that the employee can then take care of his or her own serious medical condition or the serious medical condition of a family member.
Understood. How do you get paid on these claims, Richard?
Well, if I'm doing
I'm sure
defense work,
people are very interested in your information, but I know that when people come to see me, they're always concerned, how do I get paid? How do I get paid? How does it work with, well, let's just stick with wrongful termination claims for now.
Well, so if I'm representing a plaintiff, those cases are usually taken on a contingent fee basis, and my firm follows the same kind of standard contingent fee agreement that a personal injury lawyer would follow. The one difference, though, is that there is a basis for getting attorney's fees paid under all of these laws. So that does figure into the equation. Of course, those fees would be paid by the employer if the employee won the case. That doesn't happen until the case is over, and most cases don't proceed that far along. They don't go to trial. So the reality is that if I'm taking a wrongful termination case, I have to be confident that it's a very strong case, because otherwise, I could be spinning my wheels and getting no benefit for my client or for myself. So we really need to make sure that it's a solid claim. And then if it is a solid claim, I can take that case on a contingent fee basis.
I want to go into a couple more areas, Richard, of your practice, one of which is employment contracts. And what I'm really talking about is non-competes and non-solicitation. Would you mind telling us a little bit about that?
Sure. So that's a big part of my practice, actually. I mentioned before that the vast majority of employees in Florida do not have employment contracts. And to be clear, what I mean by that is that they don't have a contract that obligates the employer to keep them employed for any period of time. You know, like you hear about baseball players or other athletes getting a 3-year contract, right? Well,
Right.
that doesn't happen very much in the private sector in Florida. Some top executives have such employment agreements, but the vast majority of rank and file workers do not. Now, on the other hand, many employees are subject to non-compete and non-solicitation agreements, and those are contracts, but they don't obligate in and of themselves the employer to keep the employee employed for any period of time. What those agreements do say, though, is that after the employment relationship ends, the employee is prohibited, for example, for working for a competitor for a 1-year period of time, just as an example. 2 years is the maximum typically under Florida law. Or the agreement might say the employee is prohibited from soliciting the employer's clients for a period of time after the employment relationship ends. There is a Florida statute on this. It's section 542.335 Florida statutes, which basically endorses the use of such agreements and allows for the enforcement of such agreements, provided they're reasonable and provided that they're supported by legitimate business interests. And that's a whole analysis that's probably beyond the scope of this broadcast, but suffice it to say that these employment agreements can and often are enforced in Florida courts.
And it's very important, obviously, if you are sharing any information with somebody that a competitor would want, the business wouldn't want that out there, at least for a little while. They can't keep you quiet forever, but it could hurt their business if you were to immediately jump to the competition.
Absolutely. And Florida law, that statute I mentioned, recognizes that and has codified this, what used to be a judicial practice of enforcing non-compete agreements. It's now codified into law. And there are limitations on the enforcement of such agreements, but they're very common. And I'm actually seeing them increasingly for lower level employees. And that's actually gotten some attention in the press, not so much in Florida, but in other states where, for example, you might have, there was a case involving sandwich makers at Jimmy John's being subject to non-competes, believe it or not. You know, can you imagine a sandwich maker is prohibited from going across the street to Subway? That probably pushes the boundaries of when a non-compete can be enforced. But they certainly can and often are enforced against high-level executives, salespeople, engineers, people with access to confidential information, trade secrets, people who have developed customer relationships, and they're often used by businesses. And that's a big part of my practice, actually, is litigating these cases.
One last area, Richard, and then I'm going to let you go. And I do appreciate you giving us the time here today. It's been very helpful, very educational for me, and I'm sure for everybody else. I know we see a lot of times people advertising, lawyers advertising for overtime, wage claims. Can you tell us what those are and how you handle those cases?
Sure. Well, I'm glad you asked, because that's actually the most common type of employment claim that's asserted in Florida, far beyond, the lawsuits involving discrimination or under the Family Medical Leave Act, for example. Overtime claims are very popular because, frankly, a lot of employers in South Florida don't follow the strict requirements of the law. The Fair Labor Standards Act, which is a federal law, says that employees must be paid overtime at time and a half, the regular rate, for hours worked in excess of 40 per week. It also establishes a minimum wage. There's also a Florida law governing the minimum wage, which is higher than the federal law. There are also what we call exemptions. Some employees, as I'm sure everyone is intuitively aware of, don't have to be paid overtime, right? Lawyers don't get paid overtime. Doctors don't get paid overtime. So there are certain exemptions from the law that allow employees to not be paid overtime. what happens in these wage and hour claims is that oftentimes the employees are saying either that they were misclassified as non-exempt, and in fact they were entitled to overtime, or they were properly classified as non-exempt, but they didn't get paid the overtime as the law requires. Sometimes employers simply pay them straight time and don't pay the overtime premium. Sometimes employers allow employees to work off the clock, meaning the clock shows 40 hours, but the employee actually worked 52 hours, for example, in a week. Sure. And so these are very popular claims. In terms of how I handle them, if I'm on the defense, I take a look at the outset of the case at the earliest possible time to see whether there's liability, because if there is liability, then we want to shut down the case as quickly as we can, because if we don't, the attorney's fees on the other side run up and the plaintiff is entitled to prevailing party attorney's fees. So those are cases that very rarely go to trial. They usually settle at some point during the case, and frankly, it's usually in the parties, at least in the defendant's interest, to settle early if possible. The challenge comes sometimes in determining just how much is the case worth. How many overtime hours did the employee work off the clock, for example? It's not easy to determine that in many cases. Or another example is, was the employee properly classified as exempt? I have a couple of exemption cases right now where we're asserting that the employee was properly classified as exempt and the plaintiff disagrees. So we're litigating that issue.
And when you say prevailing parties, you're talking about getting paid by the at-fault employer.
That's right. That's right. So if I'm representing the plaintiff on these cases, then my settlement does include a portion of attorney's fees paid to my firm. If I'm on the defense, then the settlement includes attorney's fees paid to the other side. By the way, I may have misspoke. I said prevailing party. The FLSA is actually pretty strict. It typically does not allow attorney's fees to be paid to the prevailing employer, the prevailing defendant. It's really more of a one-way street. The prevailing plaintiff is entitled to attorney's fees if he wins the case. And so it's in everyone's interest to look at the case early on and determine, is this a case that should be settled? Because if it needs to be settled, it should be settled early on before the plaintiff's attorney runs up his fees.
I can understand that. Well, Richard, again, thank you so much for your time. Greatly appreciate it. Can you tell everybody again how they can reach you if they have any further questions?
Sure. So, again, my phone number is 954-369-1050. You can also Google me, Richard Tuschman, Tuschman. I'm the lawyer, not the artist. There is an artist named Richard Tuschman. He's a distant cousin of mine, very talented. That's not me. My talents lie elsewhere. And my website is www.tushmanlaw.com. So thank you for your time, Jeff. I really appreciate it.
It's my pleasure. Hopefully I'll see you again very soon.
Very good.
And again, I appreciate all of you for watching, listening. If you have any questions for me, my name is Jeff Adelman, phone number 954-341-2777. Email address jeff@adelmanlawyers.com, ADELMAN lawyers.com. Again, thank you for tuning in. Next week, we have a show on Tuesday, April 23rd with Nancy Brodsky, Coral Springs divorce attorney, and she's going to be talking about family law and collaborative divorce. I think last week I had mentioned that, but I was mistaken. It is on Tuesday, and you will not want to miss Nancy. It's going to be a great show. Thank you for all of your support, and if there's any other questions that you have for Richard, feel free to contact him. And if you have any guests that you would like to see on Questions for Lawyers, feel free to reach out to me anytime. Have a good day, everybody.